Good day, Crime Talk aficionados. It is March 5th, 2022. It's Saturday. So what does that mean? It means the weekly recap of all the top stories in one convenient location. All right. We hope you enjoy the recap. We'll see you next time on Crime Talk. Next on the docket, Barry Morphew, I think, got some pretty good press the other night from NBC Dateline. They, being NBC, sat down with Barry Morphew's sister, Marcy McClatchan, and she gave an exclusive interview, and she described how distraught Barry was when Suzanne went missing. As a reminder, most people know that Suzanne Morphew disappeared, and Barry's been arrested and charged with first-degree murder, tampering with physical evidence, and attempt to influence a public servant. He has pled not guilty, and we will give him the presumption of innocence. Well, his sister said that Barry was very emotional when talking to her on the phone. He said she went out on a bike ride. She didn't come back. The girls have been texting her, and I've been calling her, texting her, and she hasn't responded. Now, the NBC story brought in a couple of local experts. One was former district attorney George Brockler, who basically said, hey, you got some stuff here that looks suspicious. The husband is always the first suspect. He's dumping trash. Hey, if you dump trash once, okay, that's reasonable. But 2, 3, 4, 5 times, that's a little weird. They also had Scott Robinson, a very well-known attorney here in Colorado, been practicing for a very, very long time. A great guy. He basically said, yeah, there's problems with the case, but the biggest factor for the defense is the fact of the DNA that was found in the glove compartment. But the thing was, the show didn't really go into that. I thought it was still a little, this is my opinion, so let's just be clear. I thought it was a bit of a puff piece. I think they tried to be fair, but I think they realized and are trying to lay the groundwork a little bit that the prosecution has some problems. Didn't lay out as many problems that I think the prosecution has in this particular case, but I get it. They're trying to show people what they want to hear. Anyway, obviously, Barry has a trial coming up in May. We'll see how that goes for him. Right now, I think he's got a pretty good shot. No guarantee that he's going to be found not guilty, but you never know. The only thing on the docket today is the response filed by the government as it relates to the motion filed on behalf of Chad Daybell through his attorney, basically asking for a severance of the trial as it relates to Lori Vallow. Okay, let's talk about this. The indictment alleges conspiracy to commit first-degree murder. Conspiracy is nothing more than an agreement of 2 or more people to commit an illegal act, taking some step in furtherance of that act. And so therefore, you're in a conspiracy. You're together. The evidence against one is going to be used against the other. So then the issue becomes, as it relates to Lori Vallow and Chad Daybell, well, should the evidence be the same as it relates to each other? And what if Lori Vallow isn't there? And in my humble opinion, I don't think Lori Vallow is going to be joining us, okay? And even if she did, I think they would go an NGRI just based upon the amount of time it's taking to restore her to competency, which apparently has not yet been completed. So the evidence is basically the same. Now, Mr. Pryor, on behalf of Chad Daybell, filed a motion for severance, which was very generic and made kind of just the general claims that severance should be granted because it would be unfair. Well, under the Idaho rules, and most rules that are the same in most jurisdictions as it relates to severance, if there's evidence that is admissible as to one co-defendant but not admissible as to another, then it shouldn't come in. If there are statements that are admissible as it relates to one co-defendant as to another, then it shouldn't come in, or they should be severed. And so that's really the issue in this particular case. Here, well, just because you have inconsistent theories of defenses, which is pointing the fingers at each other, it doesn't really matter. Now, I don't know exactly what the defense is for John Pryor, the attorney for Chad Daybell. My assumption would be, based upon what I've seen, is that she did it, referring to Lori Vallow, or her brother, who's now deceased, Alex Cox, did it. That would be my theory of defense. So even if Lori Vallow is there, or evidence is being brought in against Lori Vallow, so what? I get it. The defense has to file this motion. You have to file it to preserve it. You have to re-raise it at the start of trial, at the motion for judgment of acquittal, and at the end of the trial to preserve that objection. And you have to keep doing it. I once had a trial where I kept moving for severance. It was a multiple gang rape trial. There were 5 co-defendants, and every time I got up, I would move for severance. We'd go to the bench, I'd move for severance. And then at the new trial, because we had to have a new trial based on a hung jury, the government said, we are now going to agree with Mr. Reich's motion that we should, in fact, be severed from the other co-defendants in the case. And I said, I object, because I want the government to articulate what has changed other than now they think that I am correct. And, well, they really couldn't, and a lot of things changed that I can't talk about, but that's the gist of the story, okay? The whole purpose of severance is to project a fair trial. If assuming Lori Vallow is not there, doesn't join them in any way, it doesn't really matter. I think that the judge will rule that there is no prejudice. There's no inconsistent theory of defenses at this point, particularly because, well, there is no other co-defendant just yet. And it's not uncommon for conspiracy trials to proceed when one of the co-defendants is not there because they've pled guilty or they haven't been apprehended yet, but the evidence still comes in. There's no issues as it relates to any type of confession as it relates to one party that's going to be admissible as to one defendant and not to the other. That would be a big issue for motion for severance, but that is not the case here. So what does it really mean? I think what the judge will do is simply say that this issue is not ripe yet because we don't have enough of a factual basis to determine if anything that's been presented regarding inconsistent theory of defenses, co-conspirator statement issues, anything along those lines. So I think the prosecution's going to win on this particular motion. Pryor had to make the motion. He's going to have to continue to object, but the reality of it is I don't think he's going to win this one. I think the people are. Okay, have we got an interesting docket for you today. First, there's been an update as it relates to the disappearance of Orrin and Orson West. That's right. Last night we brought it to you in our live show, Breaking News. The case of the missing boys from California, Orrin and Orson West. Murder charges were filed last night against their adopted parents. They're both charged with 2 counts of second-degree murder, 2 counts of willful cruelty to a child, and falsely reporting an emergency. Now, both are in custody, but little is known as to the whereabouts of the children. Apparently, the bodies have not been found, but they are presumed dead. They're both scheduled for an arraignment tomorrow. We will be following this case as it goes. As you may recall, Orrin and Orson West are only 3 and 4 years old. It's a tragedy that never should have happened. They were adoptive parents, and their real mother wanted them. May not have been the mother of the year, but she would have taken the kids back from what we can tell. It is a tragedy in the making. So we'll continue to follow this case as information develops. First on the docket, an update regarding the Orrin and Orson West boys who went missing. Well, as we brought you the news actually live the other night, Tuesday night, when we were doing our live show, the adoptive parents have been charged. And now the authorities are saying that they believe the long missing brothers, Orrin West 4 and Orson West 3, were killed 3 months. Get that? 3 months before they were reported missing back in December of 2020. The Kern County District Attorney, Cynthia Zimmer, said it's a horrific tragedy that these precious little boys had to lose their lives. Now, Orrin and Orson West are presumed deceased. They died 3 months before their adoptive parents reported them missing. The boys' adoptive parents, Trezell Phillip West, 35, and Jacqueline Gabrielle West, 32, were indicted by a Kern County grand jury after a 3-month-long presentation of evidence. Now, Trezell and Jacqueline were arrested the other night by the Bakersfield Police Department and are being held without bail. They're charged with 2 counts each of murder in the second degree and willful cruelty to a child. Now, in the press conference, the district attorney repeatedly said she was prohibited from discussing the facts of the case, citing her own interpretation of the California rules of legal ethics. Now, although she did explain the grand jury and the indictment process while defending the decision to go to trial without the bodies of the brothers being found. Now, the search for the boys began after the tragedy had already occurred, according to the Bakersfield Police Chief Greg Terry. He said during the press conference, this is not a resolution in this case, and there will not be a resolution in this case, not completely, until these boys are brought home. When asked by reporters as to why they were proceeding without the bodies of the boys on this homicide case, the DA became somewhat frustrated and returned to a previous defense she made of trial successfully where there was no body found. Now, as we've talked about that before, it's a lot easier if you have no bodies and you can actually have some evidence as to the death of the children, an eyewitness, or the destruction of the bodies, or something along those lines. And since the district attorney is not making comment, the affidavit for the arrest warrant has not yet been released, we're at a little bit of a blind spot here as we provide some of this information, and we just simply do not want to speculate as to what evidence the prosecution has. Now, Orrin West and Orson West were named by their birth parents Classic Pettis and Sincere Pettis at birth. Their biological father, Charles Pettis, raised concerns about the adoption process and had filed a lawsuit against the Kern County officials. The father had also expressed a little bit of dismay as to how the boys' blood relatives were made aware of the children's disappearance and presumed deaths. The DA announced that they are in contact with the biological family of the boys, but did not go into detail. The DA also declined to explain why the charges against the defendants are second-degree murder and if additional arrests were planned or if others specific about the 4 other children who were previously in the West household. A second-degree murder charge in California alleges that a criminal defendant acted with malice and intent, but without premeditation or deliberation. Both defendants are scheduled to be arraigned today, and it's my understanding that took place, and they both entered a plea of not guilty. I just don't understand this case. A little weird that the police took so long to figure out that apparently these children were missing for some 3 days. I don't know if it came through some sort of electronic search of phones or something along those lines. We just don't know enough information. But it makes you think, why would these people adopt these children and then not want them? It just makes no sense to me whatsoever. This is going to be an interesting one, and hard to believe it's taken almost a year and a half for the case to come forward. You just have to be patient sometimes. First on the docket, Chad Daybell catches a break. Prosecutors in Arizona announced that they will not file conspiracy to commit murder charges against Chad Daybell in the attempted shooting case of Lori Vallow's former nephew-in-law, Brandon Boudreaux, in October of 2019. The statement from the Maricopa County Attorney's Office said, after a lengthy and careful review of the charge of conspiracy to commit murder, Chad Daybell, the Maricopa County Attorney's Office, has decided to turn down the case, citing no reasonable likelihood of conviction. Prosecutors have not announced if Lori Vallow will face charges in connection with the shooting, and based upon the evidence obtained during the investigation, police believe Alex Cox, Lori's brother and Pawlowski's uncle, drove a green Jeep Wrangler from Rexburg, fired a single shot at Boudreaux, and missed. Cox then drove back to Idaho. Now, as we know, Alex Cox died of natural causes in December of 2019 at his home in Arizona. Mr. Boudreaux told investigators that on the morning of the incident, he left his home with his 4 children around 7:25 in the morning and returned about 9:14. He said he saw a black window of a Jeep open up and a gun point towards him. The gun was fired and a bullet hit the front driver's side door of his Tesla. Chad's next hearing, where he faces first-degree murder charges, is scheduled for March 18th, and his trial is now set in January of 2023. All right, thanks for watching. Have a great week. We'll see you next time on Crime Talk.